Hello everyone, welcome to the U.S. Immigration Hub. Breaking news. A sudden shift in United States immigration policy could be closer than many people realize, and for thousands of couples across America, the stakes have never been higher. Tonight, we're breaking down how a potential return of Donald Trump to the White House could reshape marriage-based green card applications, intensify legal scrutiny, and introduce risks that did not exist just a few years ago. From new procedural hurdles to travel dangers and the possibility of automatic removal proceedings, these changes could affect anyone currently applying or even thinking about applying for a marriage-based adjustment of status. Stay with us as we unpack the real-world consequences that families need to understand right to stay fully up to date with every major development affecting United States immigration, only here on USA Immigration Hub. A marriage-based green card has traditionally been one of the more direct immigration pathways, but policy shifts can quickly turn a straightforward process into a stressful and unpredictable journey. During Trump's previous administration, the immigration system underwent significant tightening. Procedures changed, new forms appeared, and applicants found themselves facing longer wait times, added scrutiny, and more situations where minor mistakes carried major consequences. With the possibility of Trump returning to power, many attorneys and advocates warned that similar changes or even stricter ones could return. One of the biggest concerns centers around procedural changes. During Trump's last term, USCIS introduced a series of new forms designed to gather extensive details about an applicant's personal and financial life. One of these forms, often referred to as the public charge form, required applicants to prove they were unlikely to become dependent on government benefits. Even though courts ultimately ruled that form invalid, it signaled a broader shift toward tougher standards and more thorough investigations. The form required detailed disclosures about education, employment history, assets, liabilities, and even an applicant's earning potential. What might seem like everyday personal information suddenly became potential grounds for denial. Applicants who had previously sailed through the process found themselves answering complicated questions, gathering additional documents, and spending more money on legal support just to avoid making an error. If a similar form returns under a future Trump administration, the green card process could once again become longer, more stressful, and more prone to denials. Beyond forms and paperwork, travel risks are another serious issue. Many individuals with pending green card applications rely on a document called advance parole, which allows them to temporarily leave the United States and return while their case continues processing. Traditionally, advance parole has been considered low risk. As long as you follow the rules, you re-enter without a problem. But during Trump's previous term, some applicants experienced unexpected denials at the border even though they held valid advance parole documents. While broad automatic denial of re-entry is unlikely, the power to question or turn someone away lies with Customs and Border Protection officers. Professionals who follow these cases closely believe that under a stricter immigration environment, the possibility of being stopped or denied could rise again. For families considering international travel for emergencies, weddings, funerals, or even routine trips, the risk becomes part of every decision. So, under a more restrictive policy environment, advance parole may need to be reserved for only the most essential circumstances. Another major concern revolves around the automatic notice to appear, or NTA. This is possibly the most serious issue facing marriage-based green card applicants under a more aggressive immigration stance. An NTA is the document that officially places a person in removal proceedings, essentially pushing them into immigration court and starting the deportation process. Under Trump's previous policy, almost any green card denial could automatically trigger an NTA. That means, if your application was denied for something technical, such as submitting the wrong format of a birth certificate, missing a translation, or failing to receive a request for evidence in the mail, a simple paperwork mistake could suddenly land you in immigration court. In many cases, individuals who could have easily resolved the problem by reapplying instead found themselves fighting a costly, years-long legal battle to stay in the country. This created an atmosphere of fear and caution among applicants and attorneys. People became more reluctant to file if they had even a single concern in their history, whether it was a prior visa overstay, a misdemeanor, a missing document, or a financial inconsistency. If this policy returns, anyone with even the slightest complication, must assume the risk of being placed into removal proceedings if their application is denied. All of this, it raises a crucial question for families. Should you apply now or wait? With the potential return of tougher immigration policies, timing really becomes essential. If your case is strong and clear, filing sooner might be wise. But if you have complications, anything from gaps in your financial history to previous immigration violations, the strategic choice becomes a lot more complex. A case that today might just lead to a simple request for additional documents could, under a stricter administration, become grounds for an NTA. Applicants with even a 20% chance of denial must, honestly, think carefully about the risks ahead. For many families, the uncertainty alone is stressful. Marriage-based immigration is already a deeply personal process that impacts where couples live, work, plan their futures, and raise their children. Adding the threat of tougher policies, travel risks, and potential deportation proceedings can dramatically heighten anxiety. This is why immigration attorneys across the country emphasize the importance of evaluating your situation carefully and seeking professional advice before making major decisions. Every applicant's history is unique, and honestly, the consequences of one mistake can vary widely depending on timing and policy shifts. While these potential changes could make the process more challenging, staying informed is the most important tool you have. Understanding how policies may shift gives you the ability to prepare, gather documents early, avoid common mistakes, and plan your timeline wisely. Whether you are already in the middle of the process or thinking about applying soon, awareness and preparation will protect you more than anything else. The possibility of stricter procedures, advanced parole risks, and automatic NTAs does not mean marriage-based green cards will become impossible, but it does mean applicants must approach the process with extra caution, attentiveness, and professional support. Those who understand the risks will be better positioned to navigate whatever changes come next. Here at USA State, we remain committed to keeping you informed with clear, accurate, and timely updates about every major shift affecting immigration, from visitor visas like B1 and B2 to work visas including H-1B, L-1A, and L-1B to student visas, employment-based immigrant visas like EB-1 through EB-5, and family-based green cards. Our mission is to help you follow every development with confidence. Thank you for choosing USA Immigration Hub as your trusted source for U.S. immigration coverage. If you found this report helpful, make sure to subscribe, like, and share so you never miss an important update. We appreciate your support, and we'll see you in the next report with more essential news that could affect your path toward a future in the USA Immigration Hub.